Welcome back to the deep dive. This time we're going deep on something that could be super helpful for you. Understanding India's criminal justice system.
Yes.
Specifically, you're looking into how to actually challenge an FIR or a charge sheet
Right.
and the whole bail process,
All
right?
right.
We've got a whole stack of your research right here. And let me tell you, India's legal system, it's going through some major
It
changes.
really is. It's fascinating. India is really like stepping into a whole new era legally. The Bharatiya Nyaya Sanhita,
Okay.
Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshat Adhinyam, the BNSS, and BSA, they all came into effect on July 1st, 2024.
Wow.
And they're really modernizing the system. They're bringing in technology. They're pushing for faster trials. It's a massive shift.
Okay, so before we get into like challenging anything, can you break down what an FIR and a charge sheet even are? What makes them so important in the Indian legal system?
Yeah, so an FIR, a First Information Report, it's like the starting pistol for a criminal case. It's a document that's filed with the police. It details the alleged crime, and then it basically kicks off the whole investigation.
Got it.
Now, if the police, during their investigation, they find enough evidence to support, the allegations made in the FIR, they file a charge sheet with the court. And that's when things get serious because that officially accuses someone of a crime. And then, it sets the stage for a trial.
So challenging these documents means like fighting back right from the get-go.
Exactly. Yeah. And these new laws are the rule book. So understanding them is absolutely critical.
Okay, got it. Our research points to Article 226 of the Indian Constitution as like key for challenging an FIR. You walk us through how that actually works.
Yeah. So Article 226 is powerful. It lets high courts issue what are called writ petitions. So imagine, like, somebody believes an FIR against them is totally wrong. They can file a writ petition with the high court to get it quashed, basically, thrown out.
Oh, okay.
Yeah.
But what would make an FIR, like, eligible to be quashed? What are the valid grounds?
Several things. You would need to prove that the FIR lacks what we call prima facie evidence, meaning, at first glance, there's nothing there to support the accusations. Think of it this way. Like, if the FIR claims you stole a car, but you have a rock-solid alibi showing that you were out of town, that's a lack of prima facie evidence.
Makes sense.
Another ground could be what we call jurisdictional errors. So, for instance, let's say an incident happened in Bangalore, but for some reason the FIR was filed in Delhi.
Oh.
Wrong jurisdiction. That could get the FIR quashed.
So it's about making sure the case is even being, like, handled in the right place to begin with.
Exactly, yeah.
What about getting some relief while the court is, like, figuring all this out?
Well, you can request what's called interim relief. Basically, you're asking the high court to just pause the police investigation while they review your writ petition. It's like hitting the pause button on the whole process.
Okay, yeah, that makes sense. I see here a landmark case mentioned, State of Haryana v. Pajan Lal. Why is that relevant for someone considering this route?
That case set important guidelines for courts when they're considering these writ petitions. It's like a legal precedent, and it can really provide support for anyone challenging an FIR.
So it's good to have these legal precedents on your side, even if you're not in this situation, like right now.
Absolutely. Knowledge is power, especially when you're navigating the legal system.
So let's say the FIR wasn't quashed and the investigation continues. What's next?
Well, if the police gather enough evidence, they file a charge sheet with the court. And this is where things really ramp up because it signifies a formal accusation, and then the case moves toward an actual trial.
So that writ petition, it's off the table at this point, right?
Correct, yeah. Once a charge sheet is filed, the case then shifts to the trial court. And the high court's power to quash the FIR using Article 226, it no longer applies.
Okay, so what options does someone have when facing a charge sheet? Can it be challenged at all?
Yes, it can. The BNSS introduces Section 528, and that replaces the old Section 482 of the Code of Criminal Procedure.
Wow.
And this allows the high court to quash proceedings if they suspect what we call an abusive process.
Now that sounds interesting.
Yeah.
What exactly would count as abusive process in a case like this?
Oh, many things. For example, if the charge sheet relies on evidence that was illegally obtained or just wouldn't hold up in court.
Mm.
Or maybe there were major procedural errors during the investigation.
Oh, right.
Those are all situations that might fall under abuse of process.
So it's not just about the charge sheet itself, but also about like whether the whole process leading up to it was fair and by the book.
Exactly.
What happens if someone doesn't act quickly when they get a charge sheet?
Acting swiftly is really key. Delays can weaken your case significantly, so it's important to address any concerns as soon as possible.
So we've covered challenging both the FIR and the charge sheet.
Yeah.
But I think what most people really worry about in these situations is jail time. Am I right?
You're absolutely right. The possibility of going to jail is a major concern, and that's where bail comes in. And that's a crucial aspect of the criminal justice system that everyone facing these charges needs to understand.
So let's dive into that. What are like the essentials someone needs to know about seeking bail in India, especially under these new laws?
First, it's important to understand that there are two types of bail: anticipatory bail and regular bail.
Okay.
Anticipatory bail is what you apply for before an arrest, if you suspect that one is coming.
Gotcha.
Regular bail, you apply for after you've been arrested.
Okay. Let's start with the anticipatory bail. How does that work under the BNSS?
So Section 439 of the BNSS outlines this whole process. Basically, you file an application with the Sessions Court or the High Court. And in that, you explain why you believe you'll be arrested, and you highlight your willingness to cooperate with the investigation.
So what does the court consider when deciding whether to grant anticipatory bail?
Well, they consider several factors. The nature of the alleged offense is a big one. If it's a serious crime, they might be less likely to grant it. They also look at your past, any previous criminal record. And with technology now being integrated into these new laws, we're seeing courts impose tech-based conditions for those released on anticipatory bail.
Tech-based conditions like what?
Things like GPS tracking. So the court might order you to wear a GPS tracker so they can monitor your movements.
Wow.
It's really about ensuring that you don't flee or violate any conditions of your release.
So what about regular bail? How does that work?
So regular bail is when you've already been arrested, and you would apply under Sections 437 and 439 of the BNSS. The court will consider, again, the seriousness of the crime, your past, and the evidence against you.
It seems like the court has like a lot of power in these decisions. Are there any recent like legal developments that might influence how they decide?
There are a couple of key Supreme Court rulings. The Satinder Kumar and Till versus CBI case from 2022 emphasized that bail shouldn't be denied as a form of punishment.
Interesting.
The court basically said it should only be denied when absolutely necessary. And then there's also the Arnesh Kumar v. State of Bihar case from 2014. That case gave guidelines on preventing unnecessary arrests, and they stressed that bail should be the rule, not the exception.
Gotcha.
These judgments have really shaped the bail landscape in India.
This is all so insightful. We've covered so much ground already,
Yes.
from FIRs to charge sheets and now bail.
I know.
And we haven't even touched on like the impact of digital evidence yet. So before we move on, let's take a quick pause here.
Okay. Yeah, it really is amazing how much there is to know about all this.
Yeah, exactly. But speaking of learning, let's talk about how the digital age is actually impacting the courtroom.
Okay.
This is where the Pratyakshya Adhiniyam, the BSA, comes in.
Right.
This new law feels like a total game changer when it comes to evidence.
Yeah.
Can you tell us more about its impact?
So the BSA is revolutionary because it officially recognizes digital evidence.
Okay.
Like never before. We're
Okay.
talking about things like WhatsApp chats, emails, CCTV footage, all these things that we use every single day
Yeah.
can now be presented as evidence in court.
So does that mean like a casual text message could be like used against someone in court?
Well,
I'm suddenly very aware of my digital footprint.
it's not quite that straightforward.
Okay.
The BSA also outlines how this evidence needs to be verified.
Okay.
Section 65B specifically lays out the requirements for proving that the digital evidence is genuine and hasn't been tampered with.
Gotcha.
But yes, it's definitely something to be aware of.
This changes things for everyone, not just those involved in legal cases, doesn't it?
Right.
It's a whole new level of accountability.
It really makes you think about the weight of our digital actions.
Absolutely.
Yeah.
Are there any other significant ways that the BSA is changing how how cases are handled?
There are a couple of other key changes.
Okay.
The BSA now recognizes video conferencing as a legitimate way to record statements,
Okay.
which is great for efficiency and accessibility.
Right.
It also makes anonymous testimonies possible, which is especially important in sensitive cases where, witnesses might be afraid to come forward.
That makes so much sense, especially in cases involving things like sexual assault or organized crime.
Exactly.
Where witnesses might fear for their safety.
Exactly.
These new laws, the BNSS and BSA, really feel like they're bringing India's legal system into the 21st century.
They are, and it's a significant step forward. But as with any major change,
Yeah.
there will be challenges. It'll take time for everyone, the courts, law enforcement, legal professionals, to fully adapt to these new procedures. And of course, we need time for precedents to be set through case law.
And for everyone else to learn about these changes, which is what we're doing right now.
Exactly.
So to recap, for our listener who's trying to get a handle on all of this, we started by discussing how powerful Article 226 is for challenging an FIR.
Right.
And how you can use a writ petition in the high court to do that.
Exactly.
Then we moved on to what happens after the charge sheet is filed, and how Section 528 of the BNSS allows you to challenge the proceedings if you suspect an abusive process.
Right.
We also took a deep dive into anticipatory and regular bail.
Yes.
And the various factors the court considers when making those decisions. And finally, we explored how digital evidence is changing the game in legal cases.
It really is.
Thanks to the BSA. It's mind-blowing how much technology is influencing this.
It is. It's a whole new world out there, and we're all just navigating it as we go.
Speaking of navigating, before we wrap up, is there a final thought you'd like to leave our listener with, something to really ponder?
Yes. With these new laws now in effect, how do you think they will shape India's legal landscape in the coming years? And what will that mean for the average citizen? It's a really important question to consider.
That's a great question.
Yeah.
And as we wrap up this deep dive, I want to remind our listener that this is just a starting point.
Of course.
It's crucial to seek guidance from a qualified legal professional for your specific circumstances.
Absolutely.
This information is for educational purposes only.
Right.
And shouldn't be considered legal advice.
I completely agree. We're simply here to share information and spark a conversation.
Exactly. And speaking of conversation, we'd love to hear from you.
Yeah.
Tell us what resonated with you today and what other topics you'd like us to explore in future deep dives.
Let's keep the conversation going.
It's been a really fascinating journey exploring these new laws.
It has, yeah, and so relevant.
Yeah.
Especially given how quickly things are changing in India's legal landscape.
We've covered so much from the power of Article 226 to the nuances of bail and the incredible impact of digital evidence.
It really is incredible.
It's a lot to take in, but hopefully our listener feels more equipped to understand the basics.
Yeah, absolutely.
Knowledge is power, and we aim to empower our listeners with the information they need.
And remember, if you're facing any of these situations, always consult with a qualified legal professional.
Couldn't agree more. We're just here to spark your curiosity and get the conversation started.
Exactly.
Until next time, keep those questions coming and keep exploring.
We'll be here.
That's right. We'll be here ready to dive deep into whatever fascinating topics you throw our way.
Thanks for joining us on this deep dive into India's evolving criminal justice system.
See you next time on The Deep Dive.